Tidung Kurbahan, Ninwakama Giokorin, Ne Kuratimiana Pu, Mutuputile Hukan, the Katak Lakuno. And then from Gurikurin to Kolam, what in Hakaritum, for
Sir, can we start?
As you wish, yes, I'm ready.
Yeah. So then let us start. Can we please start?
Yes, sir. Hello.
Yes.
Good afternoon, everybody. I welcome you all to the 8th webinar on Kusaldas Advani at 70, revisiting the writs of surgery, prohibition and declaration, organized by Center for Public Law, ILS Law College, Pune. I warmly welcome all the guest speakers for today's session. First speaker for today's webinar, we have Honorable Justice, Chief Justice, A.P. Sahi, Madras High Court, Chennai. Honorable Chief Justice A.P. Sahi was elevated as a judge of the Allahabad High Court in September 2004. Justice Sahi assumed office as a Chief Justice of the Patna High Court in November 2018. In November 2019, Justice Sahi was sworn in as the Chief Justice of the Chartered High Court of Madras. Honorable Chief Justice A.P. Sahi is presently serving as a Chief Justice, Madras High Court, Chennai. Welcome, sir. Second speaker for today's webinar, we have Mr. Arvind Datar, Senior Advocate, Supreme Court. Mr. Arvind Datar, Senior Advocate, is a leading tax company and constitutional expert. He has appeared in several landmark cases, mostly notably the Madras Bar Association case touching upon the constitutional validity of the National Company Law Tribunal and Tax Tribunal. He has written several books, most notably the commentaries on the Central Excise Act and the Constitution of India. He is also the revising editor of Ramaya on the Companies Act and Kanga and Palkiwala on the law of income tax. Welcome, sir. Third speaker for today's webinar, we have Professor Arun Thiruvengadam, Azim Premji University. Mr. Arun Thiruvengadam is currently professor at the School of Policy and Governance at the Azim Premji University, Bangalore. He has taught extensively in NUJS, Calcutta, in the faculties of law in University of Toronto, Canada, Department of Legal Studies, Central European University, Hungary. He is currently editor of the Asian Journal of Comparative Law and Indian Law Review. Welcome, sir. Fourth speaker for today's webinar, we have Mr. Sharath Chandran, Advocate of Madras High Court. Mr. Sharath Chandran is an advocate at the Madras High Court. He is an alumnus of our college. He graduated with 2 gold medals in law and was also nominated as the best outgoing student of his batch. He did his BCL course at the University of Oxford, graduated with distinction. He is a regular contributor to the law journals, most notably the Madras Law Journal and the Kerala Law Journal. Welcome, sir. Today's session is moderated by Dr. Sanjay Jain, sir, Principal, ILS Law College, Pune. This webinar, organized by the Center for Public Law, ILS Law College. Center for Public Law was established in the year 2009. Since then, we have growing and sharing the values regarding it successfully. Center for Public Law promote the research in the area of public law and other discipline of laws. Center is always experimenting different ideas. Celebration of anniversary of the pronouncement of historic judgment is one of the experiment we are doing. Now, I request to Dr. Sanjay Jain sir, Principal, ILS Law College, to say few words about today's webinar session. Thank you, sir.
Thank you very much, Mr. Kendre. Let me welcome our Honorable Secretary and Director, Administration and Academics, ILS Law College, Vaijayanti Joshi Madam. Kendre has already introduced, my colleague Kendre has already introduced a very staff coverage of today's webinar. And, when this idea struck that we should have webinars, we started designing the concept of this whole event, and then we eventually selected 5 cases. The journey started from Gopalan, then we discussed Ramesh Thapar, followed by Champakam Durai Rajan, Shankari Prasad, and now finally we are concluding this wonderful journey with a very interesting case, Kushal Das Advani. I'm very happy to place on record the fact that during this journey we have on our platform no less than 2 Chief Justices, including today's august presence of Chief Justice Sahi. We had 3 sitting judges of High Court, 2 from Bombay High Court, 1 from Chennai High Court, and we also had we also have a number of academicians, Arun, Aparna, Chandran, etc. So apart from the academicians and the judges, we have been also lucky to have very prominent lawyers participating in the event. And last but not least importance, I would like to mention the fact that in each webinar, I have ensured that one alumnus of ILS participates. So, although we have made an effort to have a very diverse panel, but at the same time, we have also ensured that ILS is able to represent, ILS is able to display its legacy in each of its webinars. Now, coming to the topic of today's seminar, I don't think I need to say much in presence of stalwarts like Datar sir and Justice Sahi. But I would like to very briefly voice my opinion about the writ of certiorari. I was just trying to recapitulate the whole thing, because what happens when you study the writ in your classes, particularly students, you read Article 32 and 26, and generally the matter is over. And for lawyers, of course, writs are important, but do we really go into the technicalities? Now, I was reading a very interesting article written by Advocate Vikram Hegde on current bench. He referred to a very interesting judgment delivered by Supreme Court in Rangeli hydroelectrical project versus Sahu, a 2019 judgment of Supreme Court, wherein the question before the Supreme Court was whether the Hari Vishnu Kamath judgment, laying down the proposition that superior tribunals should not go into the facts, whether or not the inferior tribunals have appreciated facts, that question should not be entered into by the superior tribunal while entertaining the writ petitions dealing with certiorari. I think in this 1919 judgment, the court has partly, at least, overruled the Kamath judgment, though it is not clear whether the court has emulated the English law. The second important and interesting point which I would like to put forward and then hand over the mic to the speakers is when we look at the language of Articles 32 and 226, have we not to ask ourselves this question, that we have simply modeled our constitution on the law writs, but have we exactly copied them? Because the language is in the nature of in our constitution. And therefore I recollect a very interesting experimentation done by Madras High Court. Even incidentally, we have Justice Sahi from Madras High Court, Chief Justice Sahi from Madras High Court. Writ of certiorari mandamus. Very interesting combination, which is, I think, typical of Madras High Court, and Madras High Court has to be credited with. And it seems that no other court has tried to achieve that feat. I think I need not come between the illustrious speakers any longer. And now may I hand over the mic to Sharath to begin the proceedings. But very briefly, to tell you the entire program, Sharath will give us a brief background of the case, and Justice Shai would dive into the history. Then Datar sir will give us the contemporary picture. Then Arun, as an academician, will have the overall say on the matter. Maybe if anything left, I'll have a little bit to say, and then Q&A. So, Sharath, floor is yours.
Thank you. Thank you very much, Jain sir. Chief Justice Sahi, Mr. Arvind Datar Senior Advocate, Professor Arun Thiruvengadam. I must once again thank Jain sir for having given me this opportunity of being here today. And of course, as he knows, this is something which we worked on when I was a student at ILS in way back about 10-12 years back. Today's case of Kushal Das Advani is interesting in several respects, because part of its litigative history falls the pre-constitutional era, and part of it falls post the coming into force of the Constitution. So it gives us an opportunity to see that on the principles which the courts applied pre and post the Constitution. To give you a brief background of the case, as most of you are aware, after the partition of India, in several well-to-do families in Lahore migrated to Bombay as refugees, causing a housing crisis in the city. To tide over this, the Bombay Land Requisition Ordinance was passed in 1948, giving the power to the government to requisition any land for any public purpose. The case which we discuss today arose out of an order under Section 3 of that ordinance, requisitioning a flat on the first floor of a house which is called Paradise on Warden Road in Bombay. The tenant was one Abdul Hamid, who moved to Karachi, and he exchanged the occupancy rights of the flat with Mr. Kushal Das and his family, who were migrating from Karachi to Bombay. Kushal Das went into possession on 4th of February 1948, along with his family, although the landlord had objected to the assignment. 3 weeks later, a notification was issued under the ordinance by the Bombay government requisitioning the flat in the name of one Mrs. Dayara, who was also a refugee from Sindh. Mr. Kushal Das Advani had challenged the order before the Bombay High Court, seeking for a certiorari and for a mandamus under Section 45 of the Specific Relief Act, because as you know, prior to the Constitution, the jurisdiction to grant a mandamus was governed by Section 45 of the Specific Relief Act. And he obtained an order of injunction initially before Justice Bhagwati. Later, the matter came up before Mr. Justice N.H. Bhagwati, later who went on to become later the Supreme Court, and father of Mr. Justice P.N. Bhagwati. And after several issues that were raised before him, the only point that found favor with him was that the requisitioning order was ultra vires, since it was not passed for a public purpose. Justice Bhagwati applied the test laid down by the Privy Council in Premji Petit's case in 1914 to hold that the allotment of a flat to Mrs. Dayara did not involve any public purpose. Public purpose, he said, meant that it was for the general interest of the community and not for any particular individual. Finding that there was no public purpose involved, which was a condition precedent to the exercise of power under Section 3, Justice Bhagwati felt and held that the order was without jurisdiction, since the jurisdictional fact for the passing of the order was not met. Justice Bhagwati had crossed the first hurdle, but then the issue remained as to whether the decision in question was a quasi-judicial decision or an administrative decision, because as you know, the law as it then stood held that an administrative decision was outside the ken of the certiorari. So Justice Bhagwati said that whether a public purpose existed to support a requisition was necessarily a quasi-judicial function and not an administrative act, and was thus amenable to a certiorari. Saying so, Mr. Justice Bhagwati allowed the petition, granted a certiorari and a mandamus is prayed for against all three respondents, which interestingly included the minister, the assistant secretary to government, and the province of Bombay. The province of Bombay appealed, and interestingly, I found that Mr. Kushal Das was represented by Mr. Jamshid Kanga, and I think he was assisted by Mr. Palkiwala, and I think it was one of his early cases in 1949. The division bench of Chief Justice Chagla and Justice Tendulkar went into the issue and held that the satisfaction of the government for the requisition for the public purpose was not a subjective mental act. The government had to decide objectively. And they therefore concurred with Justice Bhagwati that the public purpose was a jurisdictional fact for exercise of power under Section 3. Now, this I found is a particularly early expression of one of our fundamental principles of administrative law. And Justice Chagla observes, since the liberty of a subject was involved, it cannot be assumed that the legislature gave the power without giving the affected party a right of being heard. Duty to act fairly implied that there was a duty to act judicially. The government had in fact gone so far as to assert sovereign immunity for the act. But Justice Chagla repelled all this and said, once there was a duty to act fairly, that the state had to act, there was a duty to act judicially. Saying so, the appeal was allowed only insofar as the writ was issued by Justice Bhagwati to the minister and to the assistant secretary. But the order quashing the notification was upheld. The Bombay High Court granted a certificate under Section 205 of the Government of India Act to the Federal Court, and the province of Bombay came up, and then the Constitution came into force. And as you know, the matter was finally heard by the Supreme Court in 1950. The appeal of the province of Bombay was allowed by the Supreme Court by a majority of 4 judges to 2. Chief Justice Kanya, with whom Patanjali Shastri, Fazil Ali, and Justice Das concurred. The dissenting judgments were by Justice Mahajan and Justice Mukherjee. Just to give you a short bullet point findings of the Supreme Court, the majority did not agree with the learned judges of the Bombay High Court that the decision on a jurisdictional fact in this case was a quasi-judicial act. They went to say that a decision was merely to see whether the public purpose was achieved or not. It did not involve any. It did not involve a duty to act judicially, and therefore it was only a purely administrative fact, which was basically can be challenged only in a civil suit. So you would find a very interesting observation by Chief Justice Kanya that we agree that it is an ultra-virus action, but we do not agree that it is amenable to a certiorari. You should file a regular suit under under Section 9 of the Civil Procedure Code. And of course, one interesting argument which was repelled was by Justice Kanya was what happens if I have to issue a notice under Section 80, and in that time I am dispossessed. Justice Kanya says inconvenience is not a question which we can go into at this stage, and it is not a ground for us to concur with the Bombay High Court, which is certainly very, very strange today. But the dissenting judges, and I found this very interesting fact of Justice Mukherjee, he agreed with Chief Justice Chagla that the decision on a jurisdictional fact is necessarily an exercise of objective based on objective facts. It is not simply which is a matter of mental satisfaction, and therefore a duty to act judicially is implicit in Section 3. Now, this is where I think I would very respectfully venture to say that the division bench judgment of Chief Justice Chagla must be credited to be the Indian anismenic at least 20 years before anismenic actually came into. And what is also of some interest, and I just wanted to just also point out that the majority in this case, at least Justice Kanya, held that it is possible for you to challenge this order under Section 3 by showing malafide. I don't know, I venture to just pose a question, and perhaps which the other speakers can also, it's a doubt which I had, whether the adding of the minister and the assistant secretary was an indication that the ground of malafide was also included in the petition, although there was no finding before the Bombay High Court. The second point is that at least 16 years after Kushal Das Advani, the Supreme Court showed that the majority judgments have been very strongly eroded by saying that a jurisdictional fact on public policy, and this is a decision which arose out of a Land Acquisition Act case, where a similar, as you know, under Section 17, the power is given to the government to dispense with the hearing procedures, invoking emergency provisions under Section 17, if it is necessary for a public purpose. The Supreme Court said that the decision on whether it is for a public purpose or not can necessarily be challenged on the ground of non-application of mind. And this, to my respectful submission, would mean that there is a very great shift within a space of 16 years from the majority judgments of Kushal Das Advani to a more flexible standard of judicial review which you find today. So with this broad introduction, I thank Jain sir and I just hand it over to him again. Jain sir, can you hear me?
Can you hear? Can I be heard? Am I audible?
Yes, you're.
Yeah. Thank you very much, Sharath, for wonderful introduction and setting the tone for discussion. I think a very important question which he grappled with is whether acquisition of property by state, and particularly when state says that it is done for public purpose, is it merely an administrative issue or is it really a quasi-judicial issue? And secondly, should we really confine the law in conceptions? Should we, as a post-colonial transformative constitutional society, should we confine ourselves with these conceptual quibblings? Let me now hand over the mic to His Lordship, my Lordship Chief Justice Sahi, to tell us more about the subject.
Thank you very much, Dr. Jain, and I thank all the panelists for having given me this opportunity to address you all. I should begin with something interesting about certiorari, in the sense that in our student days, when we had professors like Dr. Jain or even like Dr. Arun, we used to bet amongst ourselves as to if a student can spell and pronounce certiorari correctly, we would give him a treat. So that hurdle was surmounted by me and my colleagues long back in our student days. But we never thought that a day would come where we would be exercising certiorari or we would be pleading certiorari in courts of law. But nonetheless, having completed my journey almost on both sides, on the bar and the bench, when this topic was announced, I confided in Mr. Datar that as a matter of fact, this caption of certiorari fight bandamus, which I confronted here in Madras, was not a matter of even a partial study during our student days. But of course, after coming on the bench, I had heard it a couple of times, but not that seriously. When ultimately I came to Madras, I heard that caption, and then I inquired it from one of my colleagues in Patna, who said, yes, this is a very interesting topic, and it is generally mentioned by lawyers from Madras only. And then it was right in December last year that I started looking at it, and I found some very interesting material which we will talk about later. Now, coming to Kushal Das Advani, as pointed out by Sharath, this judgment as was usual in those days, is 4/2 judgment by a bench of 6 judges. And while pronouncing the judgment, they had also touched upon the history of certiorari. Certiorari is, according to the dictionary meaning, all of us know, it is in effect a certification or certainty which is sought to be established by the sovereign, and for that some records are summoned. Broadly, it is an exercise of authority which initially did begin and even continues today, that there should be no obstacle in achieving justice or preventing injustice or miscarriage of justice. The object of certiorari was to see that whatever inferior courts or tribunals are doing, it should be corrected in case it is found that it is erroneous. We will come to the nature of the error later on. But what is interesting is that this concept emanated right in the Norman times in English history. And it gradually continued with the office of the sovereign, who constituted his own jury, which later on came to be more defined as the King's Bench. It was Curia Regis, which was the caption given to the King's Bench. The consolidation of legislative, executive and judicial powers, as we all know, in England were all derived from the crown and were also subject to its control. The exercise of such powers and the issuance of such directions, which were known as writs at times, you had to pay a certain fee also. That is how the phrase purchase of writs came into being. But this gradually developed, and it took the shape of a whole system of governance which has now consolidated in England in what is known as the Judicial Review since 1981. These origins and the judicial institutions of England were all possibly an outcome of the rule of the sovereign, which we all know historically developed gradually with the emergence of Magna Carta, and later on the laws that were developed from time to time, the nature of the jurisdictions that came to be conferred, for example, the King's Bench, the Court of Common Pleas, the Court of Chancery, which all had the power to issue different types of directions which were somewhat in the nature of writs, what we know today. With this historical background, what one can see is that the practice was that the sovereign, in order to deliver justice in the entire realm, engaged the services of those judicial personalities who adorned these Common Pleas, Court, King's Bench and Chancery. And the foundational jurisprudence of the constitution of these benches was the idea that justice would be delivered in good faith. They were given the power to decide, and they were given the power to decide fairly. Now, this sums up the jurisprudence and the concept under which such writs are exercised, because there is a duty cast upon everyone who decides that he acts in good faith after giving a fair hearing, in whether it is an adversarial litigation or otherwise. Nonetheless, vis-a-vis writs, the protection of rights, the protection of liberty, the protection of property, all this came to be summarized, and the courts gradually gained power to interfere in such matters where they found that an authority inferior to the courts had acted in an erroneous way, whether it was error of jurisdiction or whether it was error of excess of jurisdiction or want of jurisdiction, or even otherwise some general nature of concepts which the English courts evolved from time to time. This greater need of power of judicial review with the expansion of recognition of rights was seen more clearly when the United States of America gained freedom. And there also, this concept of writs gradually percolated and flowered to an extent that once Lord Denning had to say that the courts in England should also have the power to declare statutes ultra vires, as is done by the US Supreme Court. Even though now that has been achieved in England as well. But nonetheless, the power of exercising writs in even petty matters had long been in vogue there. When it came to the pre-independence period in India, we have the history of the Regulating Act coming in 1774, whereby the East India Company was in a way given the authority, but later on in the early 19th century, the setting up of Supreme Courts or superior courts for the governance of particularly the three presidency towns of Bombay, Madras and Calcutta saw the opening of, for example, in Madras, the Mayor's Court and then the Supreme Court of Madras. These courts initially had been given powers, but their jurisdiction was limited, and so limited that they had to act within the territorial jurisdiction of their own presidency towns. This historical background is necessary to understand that the sovereign always understood the requirement of such writs, and it gradually gained momentum with what you can say historical evolution and the political evolution of these countries, particularly in India, when India started raising its head for freedom. We all know that the 1857 uprising resulted in the passing of many enactments and charters issued by Queen Victoria. And it also saw the development of judicial governance, breaking the umbilical cord from the previous Sadar Diwani and Sadar Faujdari Adalats, and then the formation of the High Courts under the Indian High Courts Act. Gradually, the powers which were there with the King's Bench came to be acknowledged in these High Courts, but the power of writ remained curtailed to a great extent. We find this not only on the basis of legal history, but also from the development of case law. And I will now take you to a very interesting case which I was able to lay my hands on, and which formed the foundation of the introduction of what in modern times we know of writs. This begins with the judgment that I have at hand, and all the legal luminaries here and the audience would be aware of it. And it is a matter of pride that all this history is credited to Madras itself. So this is the Privy Council decision of Rayyats of Garabandho versus the Zamindar of Parlakimedi, 1944, Madras series, page 457. When I went through that judgment, the interesting part which I came to know from it was that yet another judgment was delivered by the division bench of the Madras High Court, reported in 1912, ILR 36 Madras, page 72, which is in re Nataraja. In this case, the revenue divisional officer of Aryalur had directed the prosecution of a person. It is that which came to be challenged before the Madras High Court, and the two judges who decided it, they held that no writ of certiorari should issue, but there was a difference of opinion on the issue of jurisdiction. The reason being, the Presidency Court had the authority to issue writs only within the local limits of Madras itself, but one of the judges held that no, since the Board of Revenue, from where the case arose, the matter could be gone into. This judgment was referred to in the Rayyats of Garabandho, Saryapalli, and while referring that judgment, the interesting part is that the Privy Council records, and I quote it, but so far as their lordships have been able to discover, the writ which they directed to issue, that is, in that case, was the first writ of certiorari to be issued by a court in India independently of its jurisdiction over a presidency town and over British subjects or their servants. The historical importance of that case is subject to any further research, that was the first writ that came to be issued by the High Court of Madras. That very case, Rayyats of Garabandho, Saryapalli, records the opinion of legal luminary of those times, the then Lord Chancellor Viscount Simon, and he defines the jurisdiction, and then he says that the judge who held that they had no jurisdiction beyond the territorial limits of Madras was correct, and there was no occasion to found a general jurisdiction outside the presidency town, independent of and inconsistent with the other provisions of the charter. So this was one of the first decisions given by the earliest decisions, I wouldn't say first, earliest decisions, but prior to that, there is one very interesting decision of the Privy Council, which I am citing because taking a clue from Mr. Sharath Chandra and about the journey from Kushal Das Advani to now again back to square one. I would say that the House of Lords had very early described this in a very, very subtle language. This judgment is the Board of Education versus Rice, 1911 appeal cases, page 179, where they confirmed and affirmed the decision of the Court of Appeal in Rex versus Board of Education, 1910, 2 King's Bench, 165. Now I'll just quote a few lines, just a few lines from that decision, and how succinctly the Lord Chancellor, Lord Loeburn, described it. That case was a dispute relating to discrimination between the extending of teachers' salaries in church-controlled schools and other provided schools. The church schools were being differentiated. It is this decision of the Board of Education that travelled to the House of Lords, and the Lord Chancellor says, why, as to when will such exercise of certiorari or mandamus be permissible? He says it will, I suppose, usually be of an administrative kind, but sometimes it will involve matter of law as well as matter of fact, or even depend upon matter of law alone. I need not add that in doing either, the Board of Education must act in good faith and fairly listen to both sides, for that is a duty lying upon everyone who decides anything. The Lord Chancellor then says the board is in the nature of the arbitral tribunal, and a court of law has no jurisdiction to hear appeals. But if the court is satisfied either that the board have not acted judicially in the way I have described, or have not determined the question which they are required by the Act to determine, then there is a remedy by mandamus and certiorari. Now this decision, which is the English law long back laid down in 1911, and more than a century has passed by, now cannot be said to be obsolete law. And therefore, as Mr. Jain pointed out, that from Kushal Das Advani and now in Rengali hydroelectric project, Odisha, I also think that the said principle, age-old principle, I would say, still continues to hold water. And why I say this is that, as Sharath Chandra pointed out, a writ is not exercised only if there is a substantial question or a pure question of law. That will depend upon the facts of the issue arising and the law applicable. Now here I would like to just read a little bit from Halsbury, 5th edition, volume 61, paragraph 613. I am reading it for the benefit of everybody, because when would a writ lie is essentially to be understood in this historical background and legal background. The distinction, para 613, the distinction between what will be treated as a question of law and what will be treated as a question of fact is one of importance. There is often difficulty in deciding whether a question should be classified as one of law or as one of fact. Determination of the primary facts is not a matter of law, but to make a finding unsupported by any evidence is an error of law. Drawing inferences from the facts as found, and in particular determining whether the primary or secondary facts fall within the ambit of a statutory description, are potentially classifiable as questions of law, as questions of fact, or as questions of mixed law and fact. I think this principle, as enunciated in Halsbury, should clarify this. But again, I would like to fortify it by some decisions which do hold. And even the latest decision of 2019 also says that a certiorari will lie if the error of fact is perverse. Perversity is the ground which is carved out. Now, what are these writs exercised for? Are they only for errors of fact and law from inferior tribunals? Or, as pointed out in Justice Mukherjee's minority judgment, they can touch upon administrative law as well, administrative orders as well. Well, the law that we have been now following, and particularly in the background with the nature of duties and responsibilities now cast upon executive authorities and even administrative authorities, of deciding a list or deciding the rights of a person that touches upon his either liberty, property, or any of the rights guaranteed either under the Constitution or otherwise, we cannot narrow down the scope of writs so as to exclude even administrative decisions. Administrative decisions are also decisions that are susceptible to challenge, inasmuch as they also deal with and they decide the rights of persons. This decision making process, as pointed out in the English decisions, and as I have just now indicated, that it is an action taken in good faith and in all fairness, where objectivity is involved, where the applicability of law is involved. This determination, this power of determination itself, therefore, carries with it this responsibility of even deciding an error of fact if it tends to be perverse or otherwise relates to a jurisdictional issue or an issue which directly affects and impinges upon any such right either vested or conferred by any statute. The width of a writ, therefore, cannot be minimized, particularly in these modern times when we have so many rights, and as you know, as many laws are there have to be remedies for the enforcement of such laws and for even otherwise. The prerogative writs which are contained in the Constitution, as rightly pointed out by Professor Jain, the width of that deserves to be understood. I will just refer to Article 32 of the Constitution of India, which spells out, but the distinction between 32 and 226 has also to be understood. 32(2) enumerates that the court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, the following phrase is very important. Please keep that in mind. Whichever may be appropriate for the enforcement of these rights. Now, please contrast it with Article 226. 226 clearly says that writs, including in appropriate cases, any government within those territories, directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them. This phrase, or any of them, is not there in Article 32, but there it is, whichever may be appropriate. Further, for the enforcement of any of the rights and for any other purpose, this width under Article 226 therefore is much more wider. And here I would like to remind all the viewers as well that this is what was enunciated in the case of T.C. Basappa versus T. Nagappa, AIR 1954, Supreme Court, page 440. Historically, we have been continuously acknowledging this power, and this was followed in Yakub versus K.S. Radhakrishnan, and then of course in Hari Vishnu Kamat versus Ahmad Ishaq. This background and development of the law of writs, particularly the writ of certiorari, has grown and evolved in a manner that it embraces within it almost every aspect of such rights, particularly fundamental rights under Part 3, the most important fulcrum whereof is Article 14 and Article 21. The writ of certiorari has to be exercised even if an administrative authority, and there are no dearth of examples, I need not cite any judgments after judgments which are available, indicating that administrative decisions are not immune from the scope of exercise of writ of certiorari. And it is for this reason that in England also, the old remedies were all consolidated. And after 1950 in England, advances were made. One was to extend the remedy of prerogative writs, and the other was to develop the remedy by ordinary actions, so that to make available equitable remedies like declaration and injunction more easily. What I intend to say is that the power of writs, as enjoined under Article 226 of the Constitution of India, according to Basappa's case, has gained proportions and it has developed gradually, and rightly said in Basappa's case that it is no longer necessary now to delve into the history of writs so as to define its contours. It has now to be defined on the contours as it now exists after the advent of the Constitution. And consequently, I would say that Hari Vishnu Kamat was a step ahead, and it has taken courts to examine matters which otherwise, on account of a narrow definition, were beyond the purview of the writ jurisdiction of the courts. Life today is intermingled with every moment the right to breathe, the right to drink water, particularly you have now witnessed these COVID times. There are so many rights which are required to be protected, and so many remedies which are required to be given. One thing I may clarify, that certiorari is taken to be a remedial writ and not an appellate power. It is correct that it is a remedial power, but the other way around, lawyers must have come across this. A remedial writ cannot be used as an instrument of punishment. While exercising certioraries, at times we come across judgments that officers are summoned and strictures are passed against them. Well, that power with the court to castigate an authority if malefides are established is no doubt there, and this power cannot be taken away. But when it comes to an exercise of a writ of certiorari, and if an order of an administrative officer or an executive authority is not coupled with malefides, then it is not necessary to punish the said officer or even otherwise impose such costs as we usually do. A line has to be drawn where we have to find that the remedial writ does not cross the limits for which it is meant. This is only what I say of a certiorari in the background in which this writ has developed. The other honorable speakers will be talking about the other writs, but there are two other aspects which I would like to touch upon. One is that a strange phrase that I found in Madras, not a strange, people are very much accustomed here, that is certiorarified mandamus. I tried to research on it, and I came across the reference of it in Justice C.K. Thakkar's administrative law. And if reference is wanted, it is in the second edition, paragraph 3.2.14, where certiorarified mandamus has been mentioned. Taking a clue from that, I also went through Wade and Fawcett, and there also you can very easily find this. This is 10th edition, and the chapter begins with the quashing order and the prohibiting order. At page 519, I found the historical clue of this unique word certiorarified mandamus, but I also found mandamized certiorari in it, which is at page 528. So it is very interesting to learn this. So when I started researching into it, I found that the reference was made to a mandamus musified. This is the spelling used. Mandamusified Sarsurari, as contradistinction to Sarsurari-fied mandamus. When I started searching, I found in a decision of the court at California, reported in 169 California Appeal 461 of the year 1959. The city of Linwood, John M. Crow versus City of Linwood. There the plaintiff had applied for a certiorari-fied writ of mandamus. When the matter went up in appeal, this was the point taken that there is no such writ available. And the court held, first of all, we have been unable to find any writ in any code designated a writ of certiorari-fied mandamus. That position still remains intact in India also. Apparently, the phrase was first used by B.E. Witkin in a series of lectures in 1949 and later was used by Ralph N. Kleps in an excellent law review article in 2 Stanford Law Review, page 285, February 1950. And then I found that Bernard E. Witkin was an American lawyer and an author in California, who in his lecture, in order to define the combination of the usage of writs, which will be spoken of by the other honorable panelists, he utilized this and he coined this word, certiorari-fied mandamus, which was also understood as mandamus-fied certiorari. So this is the strange part of it. And now we have come to know of the history. And it has been continuously quoted in many cases also, but it has not been used as a writ except in Madras for granting any such relief. As a matter of fact, we are combining these days many writs together and even directions or orders which take the shape of a writ. It is just a very complicated situation. And for that, just the last point which I wanted to make was about when, and it is for us judges, when we hardly make a distinction between 226 and 227. The matter has now been settled in Radhe Shyam's case, where 226 has been completely ousted, but 227 still remains to be available. Now, under Article 227, the word writ is not used. And under Article 226, the word superintendence is not used. So this combination was now thought to be experimented, and way back in 1951 Allahabad, Motilal's case, I could see that they said that judicial superintendence means judicial superintendence, and therefore Article 227 of the Constitution may not be available for issuing of a writ. But at the same time, I would just inform all the viewers and panelists to kindly have a look at AIR 1957 Allahabad Full Bench, which categorically deals with this issue and has very succinctly laid down the distinction between 226 and 227, which later on came to be considered in the case of Radhe Shyam versus Chavinath, where they overruled Surdev Rai's case. So what I'm trying to say is that there is the words of, even though they are next door, the words are entirely different, and 227 is meant for a different issue altogether. So in the given circumstances, a writ under Article 226 may not be issued, but a direction to keep the court below within its bounds can be issued. And the law, as I pointed out, AIR 57 Allahabad has very succinctly explained the same. I would thank Professor Jain and all the people who are listening to me for having given me a patient hearing, because at the time, most of the time, we are on the receiving end. Nonetheless, Kushal Das Advani, I think, and I will hold it, that the minority view of Justice Mukherjee is the real crux of the law, which deserves to be practiced in writs of certiorari in this country. Thank you very much.
Thank you very much, sir. Thank you very much, Justice Sahi, for taking us into historical details, and then I think touching a very important point. And I think it is the crux of the entire issue. If there is a list inter partes, then be it rising out of administrative power or executive power or quasi-judicial power, judicial power. In post-colonial constitutionalism scenario, I think such issues cannot be left aside by the courts. That's what I think His Lordship was trying to hammer on in his speech. Now, may I request Advocate Datar, Arvind Datar sir, to give us perspective, contemporary perspective of writ of certiorari, and probably he would also touch on writ of prohibition and declaration. And if time permits, I would also request him to briefly touch on the famous dispute between H.M. Sirvai and H.W. Arvind for certiorari and dealing with NS Manic. Thank you, sir.
Thank you all. I must first thank ILS Law College for arranging this series of lectures, starting with A.K. Gopalan and coming to Kushal Das Advani. Before I continue, I must say it's a privilege to be part of a webinar with Chief Justice Sahi, whom I highly regard, and I've very seldom come across a judge who is so well-read and so knowledgeable as Justice Sahi. I don't say it just as a matter of flattery, but when I appeared before him one day, he told me that there was a book on bribes, and by John Noonan, and I was amazed to see the amount of research that had gone into the aspect of bribes right from Roman times onwards. And even now, you would have all noticed his research into certiorari-fied mandamus. I've been practicing in Madras and Delhi for 40 years, but I never knew that this certiorari-fied mandamus, like the branch roots of a big tree, go up to California, which is literally just exactly opposite part of our globe from Madras. And this is the word of sir, because people in Delhi always make fun of me. What is your high court? They say certiorari-fied mandamus. And the other unique thing of Madras is this lunch motion. They said, what do you mean by lunch motion? Another unique feature of Madras High Court. But I think each court has got its own, I would say, unique features which add to the charm of that particular court. Like in Bombay, you have always found that the chamber judge sits in a jacket and a tie on the floor, not on the dais, but downstairs, and hears matters. That has, again, I found it to be unique. Nevertheless, I'm also delighted that Arun Thiruvengadam is here. He was an intern with me, and I must say honestly that he was one of the brightest interns I had for the last 30 years. Now, this topic has been chosen quite properly, Kushal Das Advani. You know, what happens is, when you talk of the ancient cases, Kushal Das Advani has not been a cause célèbre like A.K. Gopalan or Anwar Ali Sarkar. Very seldom do you find in debates and discussions a topic raised of Kushal Das Advani. But to my mind, it is an equally important decision. And what is fascinating about this case is that it has an absolutely star-studded galaxy of judges, starting with N.H. Bhagwati, just N.H. Bhagwati. To my young friends, young students, I I always felt that Justice Bhagwati wrote beautifully. As a tax lawyer, nobody has defined agriculture better than him in the famous case of Raja Binoy Sahas Roy. And those of you who want to study what is the real scope of Article 254, you can do no better than read Tikaramji, which still is a brilliant exposition of Article 254. So you had Justice Bhagwati at the beginning. Then, of course, you had that fantastic bench of Chagla and Tendulkar. It's still regarded as one of the finest benches. And then for the Supreme Court to reverse the views of Bhagwati and Chagla and Tendulkar must have been quite an amazing feat on the part of Setalwad to persuade them to reverse this view. In fact, when I was, and incidentally, the other interesting thing of Kushal Das Advani is that it's a bench of 6 judges. And when I read the book by Govind Goyal, he has given an analysis of the various judges. It appears that in our constitutional history, there have been 48 judgments of 6 judges. And I was wondering why Kushal Das Advani is by 6 judges. And the answer seems to be there are only 6 judges in the Supreme Court at that time. So this must be an actual full bench in that sense, where the Supreme Court sat en banc. In A.K. Gopalan, you had 5, but here you had 6. And I fully agree with Justice Sahi that I would tend to believe that what first Bhagwati said and what was confirmed by Chagla and Tendulkar and Justice Mukherjee's view seems to be the better view. One of the feature of Advani versus A.K. Gopalan is that this judgment is very important for a student of constitutional law from the point of view of the view taken by the minority judgments. I still maintain that Justice Fazal Ali's dissent in A.K. Gopalan is really a masterpiece in its own way, where he thought way ahead of his time on the scope of Article 21. As all of you know, the other dissenting judgment in Gopalan was Mahajan, but he set aside his detention on a very narrow point and said, I'm not expressing opinions on Article 21. So now coming back to Kushal Das Advani, for me, on a personal note, I'd like to just, with the permission of Dr. Jain, digress outside constitutional law. When I wrote Courtroom Genius, we first started writing it with Mr. Soli Sorabji, and first thing he told me was, that young Nani's rise to stardom, so to speak, legal stardom, began with Kushal Das Advani. He joined the bar in 46 and he's appeared in this case in 48. So when I went and met Behram, and I had more than a dozen meetings with Behram Palkhiwala, and he told me that this was the case which changed the fortunes of Palkhiwala, and it's just fortuitous. I mentioned this in my Courtroom Genius, but I'll just take the trouble of mentioning it to others. This case was, as Sharath has already given the background, a case involving requisitioning of property. That was a big problem in those days. Mr. Sorabji said that there was a huge influx of refugees, and this was a very, very big problem. But nevertheless, Mr. Kola was engaged to appear for the Mr. Advani, and in reply, he started his he made his submissions at the end of the day, and it had to be continued the next day. But he was, for some reason, completely occupied in a part-heard matter, and he couldn't appear. And he asked Palkhiwala to continue the next day, who was his junior in the matter. And Behram remembers that he did not sleep the whole night. Palkhiwala did not sleep the whole night, particularly because there were 2 Madras judgments against him and 1 Calcutta judgment against him, and he had to get over it. And I believe when he started arguing, after half an hour, word spread that one young 2-year-old lawyer is arguing a case in the Bombay bar. And Behram's wife, Dhan Palkhiwala, remembers all the students rushed, because the college is just nearby. They all rushed to the court to listen to Palkhiwala. And so impressed was Bhagwati that he said, yeah, you please continue. And MP Amin, to his great graciousness, he said, my lord, this young lawyer is arguing very well. Let him raise new points. Many points have not been raised by Mr. Kola, but I won't come the way. But just give me a chance to rebut it again as a Sir rejoinder. Fine. The rest, as they say, is history. Palkhiwala succeeded before Bhagwati. Of course, when the matter went to Chagla and Tendulkar, it was Sir Jamshedji Kanga who appeared along with Kola and Palkhiwala. If you see the report, you'll find Sir Jamshedji Kanga with Kola and Palkhiwala. So Kushal Das Advani was not only important for laying down the law of certiorari, but was perhaps the beginning of a absolutely stunning journey of a lawyer like Nani Palkhiwala. Now, coming to this, due to shortage of time, I discussed with Justice Sahi and with Arun, and I said I'll focus only on prohibition and Arun will then take over on the writs. So I'll quickly come to prohibition because I'll try to finish as fast as possible. The writ of prohibition, as I found it, I did some research and I had a lot of slides, but I've just cut short the whole thing. Sharath, just keep me ready with the slides if you can.
Yes, sir.
Yeah. So the writ of prohibition is basically what it means. It is to prohibit an inferior court or inferior tribunal from exercising jurisdiction which it does not have. As the Supreme Court said, it is to prevent usurping jurisdiction or lack of jurisdiction. I've just given on the slide here the meaning of the word in corpus juris secundum. There's a similar definition in Black's Law Dictionary. And historical background, because as Justice Sahi mentioned, now we don't have to much go into history. We have developed our own jurisprudence. But academically, it started with the conflict between the ecclesiastical courts and the king's tribunal. In fact, even the contempt jurisdiction was the offshoot of the conflict between the ecclesiastical courts and the temporal courts. So this was a conflict between the ecclesiastical courts and the king's tribunal. And then ultimately the king's tribunal wanted to put the ecclesiastical courts in their place and said that, look, as a ecclesiastical court, you confine yourself to religious matters. You're prohibited from getting matters which are the basic matters in the realm of the king's tribunals, the king's court. So that was what they... Sorry, yeah. Next slide, Sharath.
Yes.
Now, I mentioned the modern writ of prohibition. It is to prevent a body from acting unlawfully. And the second point is important. We started with judicial acts. And like certiorari after A.K. Kraipak, you have gone beyond judicial acts and now gone to administrative acts also. Incidentally, I'll stop here for a minute. And if you see both Article 32 and 226, prohibition is the only word not mentioned in italics. You will find that habeas corpus, quo warranto, certiorari, mandamus, all are mentioned in italics. Only prohibition is mentioned in simple language because it's not a Latin word. It's used as an English word. I found it rather unusual that only prohibition is mentioned in plain English. And it's now gone to administrative acts also. It is to prevent a public body from exceeding or abusing its statutory powers. Now just go to the next slide. Yeah. The certiorari and prohibition are basically at two stages. In simple terms, certiorari is after the event, after the order is passed, you can quash it on grounds like error of law and so on. And prohibition is to stop the person. It's more preventive rather than curative. One point I want to mention is these are two important judgments on prohibition. I just made the slides for the younger audience. That Govinda Menon's case, which is very important. And what is important there is Subbarao, Justice Subbarao says, it's not only in the case where there is a absence of jurisdiction, excess of jurisdiction, but even where there is a departure from rules of natural justice. So this is a very unique point. Even if you feel that the concerned authority is departing from the principle of natural justice, you can issue a writ of certiorari. Right? Then Isha Bibi says that where there is total absence of jurisdiction, you can issue a certiorari. Now, in practical points, I had the occasion. I always feel that prohibition is a writ which many lawyers forget, and it's a writ which you can use for several matters. And I had the occasion of using prohibition again and again and again, particularly in tax matters. And this came because of list 1 and list 2 of our constitution. As all of you know, the union list has certain taxes, income tax, central excise, customs duty, and so on. And the state has certain taxes, sales tax, excise duty on alcohol, electricity duty, and so on. And Godfrey Phillips has said, the constitution bench, that there can be no overlapping of taxes. Now, after the advent of service tax and after the 46th Amendment, the 46th Amendment said that you can levy a sales tax on transfer of right to use and on restaurants and so on and so forth. So these were taken to be deemed sales and sales tax was levied. Now, these transactions also had an element of service tax on them, that there was an element of service. And you found that, let's say, for example, development of software. Software is goods. So there was sales tax on goods, and there was also service tax on goods. So the moment a show cause notice came, I would file a writ of prohibition saying that, look, this transaction is covered by sales tax, and you can't levy service tax. And I would always accompany it with a writ of declaration, where you have a writ to declare a particular provision as ultra-virus, Article 246 read with entry so-and-so, and also combine it with a writ of prohibition. So prohibition was very, very important, where there was overlapping of taxes, and I had to say that if it was coming in list 2, the union was prohibited from levying it. They couldn't make such an assessment. And if it was in service tax, it could not be subject to sales tax. If it's subject to union tax, it could not be subject to a sales tax. So typically, I used to combine it with a writ of declaration and a writ of prohibition. Incidentally, declaration also is not mentioned in the Constitution, but it's an important writ where the court has the power to declare a statute as ultra vires on grounds of legislative competence or Part 3 or and so on and so forth. Now, one observation I wanted to mention in the Tirupati case, the Supreme Court mentioned that it should be issued in the rarest of rare cases. I don't agree. Why rarest of rare cases? If there's no jurisdiction, that's it. Why should it be a rarest of rare case? So I don't think that this observation is correct, but I just thought I'll bring it to the notice. Let's go to the next slide, please. Yes. Now, writ will extend to administrative authorities. It's R versus London Council. In India also now it's settled law, so we don't have to waste time. One very important point from the point of view of lawyers is that the moment you file a writ, the first hurdle you face is alternate remedy. The first question they say, why don't you go back to the alternate remedy? Of course, as a tax lawyer, I believe that alternate remedy is only a theoretical remedy. There is no remedy at all, but then that is the way the law goes. You have to go up the channel, Assistant Commissioner, Commissioner Appeals, Tribunal, High Court and Supreme Court. Now, there is a fascinating observation by Venkatrama Iyer. It's a minority view. It's para 144 of Bengal Immunity. And he says that if it's a writ of certiorari, alternate remedy is a very material factor. You can deny relief. But if it's a writ of prohibition and the petitioner can demonstrate lack of jurisdiction or usurpation of jurisdiction, then prohibition is a matter of right. It's not a discretion. And that's the observation of the Supreme Court. So the moment if I can show that a sales tax officer is trying to levy income tax on a very extreme case, then I have a right to get a prohibition, and an alternate remedy will not be a bar at all. So that's very, very important. Though I have had this case where sometimes judges will say that, look, you can still go and tell it to the authority. But this is the point I've been citing. It's a minority view, but I think it's the correct view. Of course, the majority doesn't touch upon this. He just goes into this issue. Now, as I said, certiorari after the order is passed, it's preventive. Now, just go to the, yes, go down a bit before I get to the, I think I can't see its impact of Article 227 on Article 142. I don't have the time to get into the issue of 227. You see, a large part of our debate vis-a-vis English law is gone because now they said 226, 227, 136, all part of basic structure. You can't take it away. So the power can't be questioned. Judicial power is there. But even in 227, when the High Court has exercised powers of or the tribunals in it, it will equally have the right to issue writs of certiorari and mandamus. Now, Article 142 is a very, very unique article, and like many students of law, we sometimes wonder with amazement how this article, the Constitution has given certain specific powers. Now, my colleague brought to my notice Article 139. If you've got a Constitution Barrack with you, please see Article 139 for a moment and read it with Article 32. Article 32 says that 32.2, which Chief Justice Sahi just read, says that you can issue these writs, habeas corpus, quo warranto, etc., for enforcement of fundamental rights. Now, if you see 139, Parliament may by law confer on the Supreme Court power to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, for any purpose other than those mentioned in clause 32 of 32. Now, I have not been able to locate any such parliamentary law where they have said that beyond Part 3, you can use Article 32 to issue orders. So one point could be taken is when you're before the Supreme Court is confined to Part 3 and cannot go beyond, whereas the High Court is not confined by that constraints because it says writs or for any other purpose. To that extent, the power of the High Court is far, far wider than that of the Supreme Court. Now, coming to Article 142, the power of judicial review is through exercise of these writs. certiorari, mandamus, prohibition. I'll ignore for the time being quo warranto and habeas corpus because they're on different footings altogether. But under what basis do you pass orders under 140, 142? The article says to do complete justice. One view is that this is like section 151 of the Constitution, that like 151 of the CPC, where you have some inherent powers to do justice, to give the finishing touches, so to speak, to iron out the creases, as Lord Denning puts it. But Article 142, in my humble opinion, has been used far beyond what it was initially contemplated. I'll just give two examples. Now, the Supreme Court levied diesel cess. They came with an idea that diesel is more polluting than petrol, and they levied a diesel cess. Now, where does the court get the power to levy a cess? 2%, 5%, and they said how the cess can be collected. So these are cases where it's not a certiorari, it's not a mandamus, it's a unique power being taken over by the Supreme Court, where they say that we can pass an order to any extent. Now, the court feels, now I appeared for the petrol cars, etc. in that matter. There's enough data to show that the pollution is not because of diesel, it can be equally because of petrol. The whole thing depends on the combustion of the engine. This is not the place to go into it, but I'm just saying this is a wide power. Other simple example is, the Hindu Marriage Act says you can't give a mutual consent divorce before a particular period is over. But in that Anil Kumar Jain case, Supreme Court says we can waive it. Okay, fine. But then they go to say that this can't be waived by the high courts. Now, for the life of me, I don't know why. If there's some power to do justice in a case, it's not in a 226, but only under 32. And other mystery which I have not been able to sort out after so many years in the bar is why the prospective overruling is only done by the Supreme Court. If the High Court has the power to strike down a law, in my humble view, it has equally the power to say that, look, it will be prospective, it will not affect past transactions. But the Supreme Court says that prospective overruling is only for the Supreme Court. Now I'll just come to the short thing of Wade and Sirwai. Very fascinating debate, and I would strongly recommend the youngsters and the younger lawyers, if you got the 4th edition of Sirwai, start with para 16.200. He starts anisminic with 16.200 and goes on. Now, what is this famous anisminic case? Anisminic was a very simple case. And incidentally, when I talk of simple, pardon me for quoting from Kushal Das Advani. I think Chief Justice Sahi must be feeling this almost every day when he hears counsel. Fazal Ali, in his judgment, starts with these words, and I'll read it. This is, in my opinion, a simple case, but it has been greatly complicated by a citation of a mass of decisions by the parties in an attempt to extract from them some principle to support their respective contentions. I suppose this is the horror of every judge, that on a simple point, multiple authorities are cited. Anyway, coming back to anisminic. See, anisminic was a relatively simple case where, as you know, in 1956, Abdul Nasser closed the Suez Canal. The younger generation may not know it now. It was a big sensation in those days where Suez Canal was closed and all the ships had to go right around the Cape of Good Hope. And I know my father was in the Merchant Navy, and he used to tell me that after 56, in fact, he was on the 3rd last ship which crossed the Suez Canal after Suez closed, and they had to go right around Africa to go to Germany and England and so on and so forth. It was a very, very big problem. Anyway, Suez Canal was closed. It paralyzed shipping traffic. And the Egyptian government nationalized assets also, including the assets of this Anisminic Limited. Now, what they did was, when the assets were nationalized, they told all their customers, don't buy anything from this Egyptian company. If you buy it, we will blacklist you, so to speak. So, out of fear or out of economic reasons, this Egyptian company said, all right, I'll pay you £500,000, but lift this ban. So, Anisminic and the Egyptian company Tido came to a settlement, and the matter was settled. So, Anisminic basically got what it wanted. Later on, there was a treaty between the United Arab Republic, which Egypt then became, and United Kingdom, and £27 million were given as compensation by Egypt to be distributed amongst the British people whose assets had been affected, whose business had been affected by this closure of the Suez Canal and sequestration of assets, as the word was used. Now, I would agree with the view of Sirwai what the foreign compensation law said was that this compensation of 27 million would be distributed by a tribunal on certain parameters. And what is most important was Section 11 of that act said that the decision of the tribunal will be final and cannot be reviewed by any court. So under the amended Section 11 of the Tribunals and Inquiries Act 1958 and said the decision of this particular tribunal will be final and cannot be reviewed. Now UK doesn't have a written constitution. If Parliament says you can't amend it, that's the end of the story. But yet an outstanding bench of Lord Reed, Lord Wilberforce, and the third judge, they said no, by majority they said that the tribunal asked the wrong question and therefore they committed an error, and the whole thing was error within jurisdiction, error without jurisdiction. Unfortunately, time doesn't permit me to go into that. But apart from CRY, those of you who like administrative law, please read chapter 16 of Craig's administrative law. Craig has, in the 16th edition, has started with Anisminic, then he goes to Rakal, then he goes to Page, then he goes to Scottish Yorkshire Company, and keeps on tracing the development of things, and then goes on to Wednesbury and so on and so forth. So he has discussed how Wednesbury Anisminic was wrong, and has discussed the whole thing. Now, of course, in India, Anisminic is academic, and if you read the discussion between CRY and Wade, CRY first criticized Wade. Then in a series of lectures by Wade, which is called Public Law, lectures on public law, he countered what CRY said. CRY wrote a very strong response to that in rather very strong term, which is worth seeing, worth reading. And I think overall I would tend to agree with CRY's criticism. And he points out in that what Wade wrote in 72 was directly in contrast with 74. So CRY's basic point was, in a country with an unwritten constitution, if your jurisdiction of a tribunal is taken away, the courts cannot interfere on the grounds of error of jurisdiction, asking the wrong question, etc. He says, puts it very nicely, Craig puts it very nicely. If the test is, has the tribunal taken into account an irrelevant consideration? Has the tribunal asked the wrong question? So Craig puts it nicely. He says that means the court has come to the conclusion that the tribunal's conclusion is wrong. Its view is correct. And why is its view correct? Because tribunal asked the wrong question. In other words, court has got answer B, tribunal has got answer A. Court feels answer A is wrong, answer B is correct. So how do you justify answer B? You tell that you asked the wrong question, therefore you got the wrong answer. So it's a very nice discussion by Craig on this particular point. So this is as far as Wade and CRY is concerned. I'll just mention one important point, that on public purpose, see, Kushal Das Advani goes on to public purpose, and there are so many cases which are not known, but which are worth considering. There is one important case, R versus Foreign Secretary, 1995, 1 Weekly Law Reports 386, 1995, 1 Weekly Law Reports 386. It's a remarkable judgment. You know, I had appeared before Justice Sadasivam and Justice Gogoi, challenging this free distribution of color TVs and freebies and so on. I said that under Article 282, you have to spend money only for public purpose. And what is public purpose is to be decided by the courts. There was a body of American case law which said, you can't use public funds to create private assets. I said, you can't give free TVs to people. You can have community television, community computers in school, that's fine. They're community assets, but you can't use public funds to create private assets. In that argument, I came across this particular judgment. It's a masterpiece, and you'll be shocked at the way, to the extent which the English courts have gone. The Secretary of State of the United Kingdom decided to give 417 million pounds as a donation, as a grant, or as a economic aid for building a dam in Malaysia. It was to be handled by one unit in Malaysia, which is supposed to be involved in that dam construction. To cut a long story short, the court says, Section 1 of the Act says, the UK government can give funds for public purposes. They say what is public purpose is for me to decide as the court. They examine the law, they examine the facts, and they say that the NGO which filed the writ petition demonstrated that this 417 million claim by Malaysia was far in excess of the cost of the dam. There were a lot of corruption issues and other issues, and the UK court struck down this grant of donation, this economic aid. So this is to the extent to which you are now gone in terms of judicial review, where a policy decision of one country to give aid to the other country is questioned before an English court, and it is struck down. So now this is the sum and substance of what I wanted to mention. I think I've covered most of my points. I'll only mention one thing, that as far as a writ of prohibition is concerned, as I mentioned, it is a writ which is not as popular or as commonly exercised as perhaps it should be. And when any lawyer gets a particular problem or a brief, if the order has not yet been passed and it is a potential danger, a threat of injury to his legal rights, then a writ of prohibition is the remedy which he can exercise, which he can which he can invoke. And very often, as I said, it can be invoked with the writ of declaration, prohibition plus this thing, or you can even simply stop a person from proceeding with a matter on which he has no jurisdiction at all. So I would thank the audience. I'll just wait for any question answers. I've summarized, I just focused on the writ of prohibition, and I'll now leave it to Arun to discuss the whole aspect of certiorari. I thought I'll speak on prohibition because that's a topic not normally spoken about. We focus only on certiorari and mandamus, but we ignore prohibition. Therefore, I thought I'll focus on this topic. Thank you very much. Thank you. All the best.
Thank you, sir. Thank you very much. Whenever Datar sir speaks, he has one or the other interesting point, and I was fascinated by the dissenting opinion he cited, and his observation about the how words prohibition is unitalicized Constitution, right? And how judicial review is becoming, how the fruiting of judicial review, how the conception of judicial review is becoming stronger and stronger day by day, even in countries like England. And I think in contradistinction with that, if I remember correctly, in India, the Supreme Court upheld that Dole decision, isn't it? It decided in favor of Jain, if my memory is correct. But that's how law sometimes shape. Now, let me invite my friend, very dear friend Arun, whom I wanted to invite to Law College for a long time. Somehow, some reason or the other, we were eluding each other. I think today is the opportunity to hear him. So, without any further ado, let me hand over to Arun. The floor is yours.
Thank you, Sanjay. I hope I'm audible. I want to begin by saying that I'm delighted to be here for three broad reasons. I'll enumerate those reasons and then I'll try and supplement what we've heard. And I think we've heard two wonderful presentations with two broad points. I want to start by saying that, as Sanjay alluded, and he's being very generous, but he's invited me to come to ILS Law College, and I've been unable to make it. So being here for this webinar in the middle of our pandemic is something that I think is a great privilege. ILS Law College, as many people on this webinar know, is one of the most established law colleges. It's going to come upon its century very soon. Last week, we were part of a webinar where we learnt of Chief Justice of India, Yashwant Chandrachud's long association with ILS, both as a student and then in other capacities. For any student of constitutional and administrative law, ILS Law College will always be special because Professor S.P. Sathe was the principal of ILS Law College till the early 90s, and then stayed on to do research and write till he passed away in the early part of the century. And I mentioned Professor Sathe because I will be invoking him as part of my presentation as well. I also want to say it's a great privilege for me to accept Professor Sanjay Jain's invitation. Professor Jain, as many of you know, is a constitutional scholar of some standing. He has produced a wonderful book on the Kesavananda Bharati judgment and has also taught students whom I have met across this country who always speak with great fondness and awe of his teaching prowess. And I think some of us have seen that on display. I think it's extraordinary that ILS Law College took a leap of faith and asked Sanjay to be their principal. Sanjay has taught me a lot about the ableist world and the discrimination that people with disabilities continue to face. I think there are scholars like Amita Dhanda and Jayana Kothari who've published important works on disability law. But I think now there's a new generation of people, and Sanjay's work on disability law will also sensitize us to the many advances that Indian constitutionalism still needs to make. That's my first reason, and I'm really glad that I'm part of this webinar. The second reason for being excited is, as we all know, this is the 70th anniversary of our constitution, and we are at a time when the Indian constitution and constitutionalism in general are facing multiple crises. So I think it's fitting that we do something to go back to the foundation of the Constitution and constitutional principles. And I think this series, I've had an opportunity to look at some of the other YouTube videos on the cases, and today Sanjay started by giving us a sense of the motivation of that. I think it's particularly significant since December last year. We have seen people gathering in large numbers before the pandemic hit, of course, across the country. And for those of us who think of the Constitution as something that we refer to every day, this was very heartening to see ordinary people referring to the Constitution and the preamble. So in that sense, I think this series, to the extent that it makes us go back to the text of the Constitution, to important cases decided by the courts, which are a very important instrument to safeguard these constitutional values. This series is, I think, very important, and I do hope that it will continue. My third reason, and this is at a personal level, as Mr. Datar was kind enough to mention, I interned with him, and I also started my career as a lawyer 25 years ago before the Madras High Court, working in Mr. Datar's chambers. Like many of you, I'm a great admirer of Mr. Datar. He is, of course, a very talented lawyer, but I think what many of us respect about him is that he has lent his talents to some seemingly lost causes, and that never dissuades him from taking up important matters at all levels, including at policy levels, and he has an admiration for that reason. My final reason for being excited, Mr. Datar mentioned that Kushal Das Advani is a constitutional case, and I think it is, but it is also an administrative law case, and I think it's important that we, as we are celebrating the Constitution, we also celebrate the poor cousin of constitutional law, the subject of administrative law. When Justice Sahi mentioned his anecdote about being able to pronounce certiorari. Fortunately, in England, as Justice Sahi mentioned, since 1981, they've taken away the Latin terms and they're simply called quashing orders. But I think law students everywhere, I myself found administrative law very difficult to follow because it seemed to be a series of English decisions which we couldn't always understand. I think today Justice Sahi has taken us through that long history in England, dating back to the 3rd century, the 17th century, and then more recent times. But teaching administrative law is often seen as a very difficult task because of these complications. Mr. Datar's presentation took us through the various difficulties of deciding what is an error of jurisdiction, what is when does an authority exceed jurisdiction, understanding the anismenic case, and the various other English cases which Indian judgments refer to quite frequently, is quite difficult for a law student. And I think perhaps because of that, administrative law doesn't enjoy the kind of reputation that certainly constitutional law does. But as a public lawyer, I've always felt that while constitutional law is very important for the meta principles and the big battles, on an everyday basis, it is administrative law which affects ordinary citizens much more. We are all affected by the actions of ordinary authorities when they impede our way of going about, and when we have grievances with them, we want to have recourse, and going to court is always quite difficult, especially in a country like India in the contemporary moment. And for that reason, I think focusing on administrative law is also very important. I see that this has been a very interesting talk already, but we are coming up against time. So I'll try and keep it brief. And let me just say, I'll adapt my presentation to what has come before. So I'll broadly stick to 2 points. The first, as Mr. Datar said, we also want to talk a little bit more about the Kusaldas Advani case. I'm grateful to Sharath, who I think in a very brief manner at the outset of this presentation laid out the facts of the case in a very lucid and succinct manner. And he's also taken us through the 2 judgments of the Bombay High Court. And he's also provided an overview of the judgments in the Kusaldas Advani judgments delivered by the Supreme Court. I do want to set a little bit of context, and that will lead up to my second point about how do we view administrative law today. So what's striking about the as Mr. Datar said, there were only 6 judges, and that's because at that time, as he mentioned, there were only 6 judges. This judgment was delivered on September 15th, 1950. A week later, the 7th judge of the Supreme Court, Justice Chandrasekhar Iyer, was appointed, and after that, you had Justice Vivian Bose being appointed. So at this time, there were only 6 judges on the Supreme Court, and as we've heard, there were 5 judgments delivered. I should say, Mr. Datar has already mentioned some very interesting aspects of this judgment. What is another very interesting part is of the 6 judges who decided this case, 5 became Chief Justices of India. So Chief Justice Kania was already the Chief Justice. A year later, he passed away, unfortunately, quite suddenly, and Chief Justice Sastry followed him. And if you look at the judgments delivered of the 5 judgments which were delivered, Justice Fazil Ali is the only judge who didn't become Chief Justice of India. But as Mr. Datar has alluded, many people go back to his judgments because of the insight they had, particularly the Gopalan case. In this judgment, as Sharath mentioned, the 2 minority judgments were passed by Justice Mukherjee and Justice Mahajan. While I think the 3 of us on the panel, the 4 of us, I'm sorry, have said multiple things. I think what is interesting for our purposes, since we're discussing a judgment with dissenting judgments, is I think all 4 people on the panel are of one mind. I think all of us think that Kusaldas Advani is indeed a landmark judgment, but not necessarily for the majority judgments. As Sharath pointed out, Chief Justice Chagla's judgment in the Bombay High Court is extraordinary because it, as he mentioned, anticipates the turn in anismenic, which was decided in 1969. But Chief Justice Chagla's judgment in 1949 anticipated that line of reasoning. I would also suggest that similarly, Justice Mukherjee's judgment, which is really a fascinating judgment to read. And I'll say a little bit more also of the style of these judgments and how they were written. But what is interesting is that the line that he takes in deciding the case and going against the majority view is very similar to the line that the House of Lords takes in the famous case of Ridge versus Baldwin, which is also decided in 1963. So what's interesting is that these judges, with their very astute training and their erudition, were able to come up with principles which were followed in England much later. And of course, the later administrative law, and I'll come to that briefly a little while later, then starts tracking what's happening in England. But I suppose the point to take would be that if you go to these judgments, you will find in the judgment of the Bombay High Court that was reversed, and in the minority judgment in Advani's case, many interesting principles that were laid down. I want to say a little bit, and this is where I will go to Professor Sathe's points, not so much about Advani. So I also checked Professor Sathe's book on administrative law. I think many people are very familiar with his book on judicial review, where he talks about, and that's the book that I will refer to, for his description of the early Supreme Court judges. One of the things that I think is worth mentioning also is just the background of these judges. Professor Sathe says that all the initial Supreme Court appointees were steeped in British traditions. Two of them had been educated in England, Justice Fazal Ali and Justice Das, but he describes their approach to adjudication as positivist, dominated by the black letter law tradition. Now, this gives you the impression that they were extremely deferential people, but here's where the work of George Gadbois is very interesting. George Gadbois has a 64-page article in the Journal of the Indian Law Institute about the federal court. And I think it's important as we turn to history, the federal court doesn't get much attention from scholars, but it was actually a very important court which between 1937 to 1950 played a very important role and in some ways was a genuine precursor to the Indian Supreme Court, because the federal court, although it didn't have a very expansive jurisdiction, although its rulings were subject to being overruled by the Privy Council, and that constrained their ability. And as the name suggests, it was really meant to safeguard the federal provisions of the Government of India Act of 1935. But as scholars like Rohit Day and Gadbois have pointed out, the federal court actually did some extraordinary things in its brief period of existence. They tried to rein in executive power of the colonial government. So if the impression that one gets from Professor Sathe's description is that somehow these were timorous judges who just yielded to the government of the day, that's not a correct impression, because all of these 6 judges had actually been appointed to the federal court. So by 26 January 1950, each of them was already on the court, and some of them had spent very long periods, right? So you look at, for instance, Justice Khania. He'd been on the Bombay High Court for 15 years, and then was on the federal court for nearly 5 years. So a 20-year judicial career. Justice Fazal Ali had a slightly longer career because he had been a High Court judge for 19 years before he joined the federal court in 1947, and he had 3 years on the federal court. So again, if you look at someone like Justice Mahajan, who before he became a judge of the federal court had been Prime Minister of Jammu and Kashmir from October 1947 to about March 1948, where he had to take on Nehru, and there's a reported row between Nehru and Justice Mahajan, right? So how do we understand what Professor Sathe is saying? I think what Professor Sathe is saying can still be understood if you look at the text of the judgments as well. So let me first start by saying what I think is extraordinary about the style of writing in Advani. It's actually, so I have a 60-page printout from SEC Online, and it's quite extraordinary. We're living in times when our Supreme Court either gives judgments of 7 pages or of more than 1,000 pages. So for 5 judgments to be expressed in 60 pages in very pithy language, I would, again, following Mr. Datar, if there are young people in the audience who want to look at judgments and how do you write judgments, I would say Justice Mukherjee's judgment, not just because I agree with what he says, but even if you look at the way he puts down these fairly complicated facts in just a couple of paragraphs, that's a model of pressy writing. And you see that the judgments also, so there are 2 minority judgments and there are 3 majority judgments for 4 judges. They are actually in dialogue with each other. They don't expressly refer to each other because that was not the style. This is not like an American judgment where they are taking pot shots at each other, but they do respond to the concerns of each other. And when you read all the judgments together, you really get a sense of the legal issues at stake and how one could go one way or the other. The majority judgment, none of us would like to endorse it, but Sirvai, to his credit, and as we know, H.M. Sirvai argued this case in the Supreme Court and lost. And typically, Mr. Sirvai used to get quite upset about judgments that didn't go his way, and in his commentary, he's scathing about Supreme Court judges. But in this case, he actually says that the majority judgment had a basis, and they were really following an older case, by Lord Atkin, decided in 1924, the Electricity Commissioner's case. And he says there were good reasons why they were following that English line of cases. But what I want to say, so having told you what I think is admirable about this judgment, what is extraordinary, and I think Sanjay alluded to this a little bit earlier, and this is where I would go to the critique offered by the great civil rights lawyer, K.G. Kannabaran, in Wages of Impunity, where he's looking at a series of decisions. He talks about Gopalan, he talks about V.G. Rao, decided in the 50s by the same 6 judges. And he says what is extraordinary is you look at the time period these cases are decided in, right? So I've given you the lineage of these judges. They were in the presidency high courts. They went up to the federal court. But by the time this case is decided in September 1950, I'm not sure when exactly the case was argued, but regardless of that, this was happening post the Constitution. And what is really stunning to me in these 60 pages is that the Constitution barely emerges. If you close your eyes, these judgments could be written by English judges. The standard of and quality of language is there, and the predominant number of citations there are to English authorities. We could say, well, that's understandable because that's the law that was applied. Chief Justice Sahi took us through how certiorari was brought into the Indian legal system. You can go back to the 1773 Act. You can go back to the 1861 High Courts Act, where certiorari is brought in, right? And these cases did originate in the Bombay Presidency. And so, of course, they had to be decided by the law that was applicable when the cause of action arose. Nevertheless, by the time it is decided, and I think there are enough provisions in the Constitution where you could argue that this case should have been influenced by the Constitution. And I think a lot of what Justice Sahi and Mr. Datar said was in their presentation, they were focusing on how the articles of the Constitution, so it's 32, 226, 227, Mr. Datar mentioned 142, you could also look at 136. Clearly, this was very different from the colonial judiciary, and there should have been perhaps a different approach taken, but none of that comes in. So even as I appreciate Justice Mukherjee's argument, he never uses the argument of what was actually merited by the facts of the case. And if you think of the facts of the case, as Sharath mentioned, Kushal Das Advani was also a refugee. The law passed by, it was not a law, it was an ordinance, which should also raise question marks because ordinances have always been treated differently than legislation. But there's no discussion of that because legally, I suppose they are law. But the idea that this was an ordinance rather than a law passed by the legislature doesn't come up. If this question were discussed today, I think these are questions we would look at. So this was an ordinance passed to allow the resettlement of refugees. But Kushal Das Advani was a refugee himself and his family, and they were going to be displaced because of this requisition order. So clearly their legal rights were at stake. You could argue that, in today's case, Article 21 would come into play. But none of this is discussed. At best, there's a discussion about public purpose. Justice Mukherjee's judgment is, I would say, progressive, but doesn't go into these larger questions, which the later administrative law cases start going into, and reverse the earlier line of cases. So to follow Kannabaran's critique, and his critique is that the early judges were very much affected by their colonial baggage. and they didn't understand that the Constitution of India, rather than being a preservative constitution, which just maintains an old order, was meant to be transformational. Right? And if you look at the facts of the case, and if you look at Mr. Advani, who is very much the kind of person who is in a very difficult situation, you would think that you would have a new type of law where you say people who are at the mercy of the legal system and have very few resources should be treated differently than they were during the colonial era. Right? So that's the point. To me, it's one of the missing things when I look at this case, although it's decided in the post-constitutional era. And I just want to emphasize that aspect. Going beyond that, I just want to say, and I see that I've got about 3 or 4 minutes left, so let me just put this out there for the second broad point. How do we think of administrative law, and what is the role of administrative law? In England, all the scholars that we end up looking at, right, whether it's Albert von Dicey, we've discussed Wade, the D. Smith text is looked at. All these are part of a tradition which two British academics in a wonderful book called not administrative law, but law and administration. This is Carol Harlow and Richard Rawlings. This is a debate internal to English administrative law. And they say that all these storied figures, starting with Dicey, going to Wade, and the great English judges, all subscribe to what is called the red light theory of administrative law. What does this believe? This believes that to rein in the administrative state, law is sufficient, but it's not all of law, but it's judicial control of administrative action. And they all believe that you can do this through the courts, through adjudication, and you do it to protect the liberty of citizens. Now, anybody who has seen the trajectory of English administrative law is bound to be skeptical of how successfully courts have been able to do that over 100 years. So we know that during the interwar period, Liversedge versus Anderson was a great example where the judges really failed to do that. There's only Lord Atkin's dissent where he talks about subjective and objective satisfaction and how do you assert that. So the courts in England really were not able to do very much during the interwar period. It's only in the 60s, and that's when you have the great cases. Ridge versus Baldwin in 1963, Annis Minnick, which Mr. Datar discussed in 69, the Padfield case in 1968. So this troika of cases by Lord Reed is supposed to have rescued English administrative law and revitalized it. And then it goes forward all the way till the 1980s. In 1985, you have the GCHQ case, right? And all these cases are later followed by our Supreme Court. And that's when it culminates in Menaka Gandhi, where you look at principles of natural justice. And the fact that if natural justice is not provided for, then courts would be justified in intervening. In England, and this is Harlow and Rawlings' point, that just relying on courts to rein in administrative action has not served even England very well. And so they talk about green light theories, which is how do you rein in the administrative state by multiple other ways. One way is through statutes. This is very much the American model of having an Administrative Procedure Act, or the South African model, where in their constitution itself, they guarantee a right to administrative action, right? And I'll just read out because this is really interesting. I'll try and see if I can quickly present this. I'm going to just take out, this is a provision, section 33 of the South African Constitution, the final constitution of 1996. Sharath, can you see my screen? Maybe not.
No, Professor.
Okay, so maybe let me just read it out in the interest of time. It's a short provision, but it's an interesting provision. The South African Bill of Rights has a specific provision guaranteeing just administrative action. And I want us to think about it because we are very much still in this English idea that courts alone can solve the problems of administrative arbitrariness. So section 33 reads, clause 1 says, everyone has the right to administrative action that is lawful, reasonable, and procedurally fair. Clause 2 says, everyone whose rights have been adversely affected by administrative action has the right to be given written reasons. Clause 3 then says, national legislation must be enacted to give effect to these rights and must, A, provide for the review of administrative action by a court or, where appropriate, an independent and impartial tribunal. B, impose a duty on the state to give effect to the rights in subsections 1 and 2. And C, promote an efficient administration. Now, in these three broad principles, the South African Constitution captures much of the development of administrative law, which in England took about 60 years. And in India, we have similarly followed this and tried to develop judicial principles of administrative law by also following developments in England. In South Africa, following their 1996 Constitution, in 2000, they enacted a law, a parliamentary law, which is called the Promotion of Administrative Justice Act. This act is guided by three broad principles: transparency, participation, and accountability. The idea is that ordinary citizens who in their daily business, these are not the great constitutional cases of fighting for the grand principles of free speech or the right to property. These are ordinary people who, when they try and get licenses or driving licenses or licenses to run businesses, they are turned away by the administration. Or let's take Mr. Advani's case, right? Here is Mr. Advani, who has a tenancy agreement. The province of Bombay is requisitioning land. He was never given a hearing. His rights were never ascertained. He was never heard about what other recourse he might have had, which is why he ends up going to court for a writ of certiorari. So I'll end with this point. In 2020, when we know the state of our judiciary, when we know the state of our pendency, which in the pandemic has only become exacerbated, I'm sure Chief Justice Sahi is deeply concerned about how he's going to handle the fresh bout of cases that come up. If we have to deal with administrative law disputes, we must think of more radical measures, and perhaps an Administrative Procedure Act or a Promotion of Administrative Justice Act is the way to go forward. As Chief Justice Sahi mentioned, the idea that purely administrative acts do not cause injustice and should not have some system of review is a really problematic idea in the 21st century. I'm so apologies if I've gone over time. I'll end here, and I look forward to hearing from the others. Thank you.
Arun, thank you very much. And now perhaps audience will agree with me when I was insisting that he should be in one of the programs of ILS. Arun always bring new points, and his particularly he drew his emphasis on Section 33 of South African Constitution is very timely. I think his point that Kushal Das Advani's personal situation should have been the focal point of the court while entertaining the writ jurisdiction, I think, is not hindsight criticism, as many may say. I think as Supreme Court of Indians, why Supreme Court of India became Supreme Court for India only in 80s. If we believe that Dr. Ambedkar had the constitution to bring transformation, I think a lot can be said about his presentation, but time doesn't permit. Sir Datar, sir, with your permission, just one question which we have received, if you can answer that question. The question is, it is asked that if writ of declaration is not mentioned in the text of the Constitution, then what is the legal sanctity of this writ and how you project it under our Constitution? If you can answer this question. Datar sir, you have to unmute yourself.
Datar sir, unmute. Sir, we can't hear you.
Sir, we can't hear you.
You have to unmute, sir.
Yes. Sorry. No, there was difficulty in that particular Yeah, tell me. Please, can you just say the question again? I was
to repeat the question. Since
sorry.
writ of declaration is not mentioned in the text of the Constitution, what is the legal sanctity of this writ, and how do you project it as a part of Indian public law?
Yes. No, the writ of declaration is not mentioned, but I would say even if it is not mentioned, the court has the power of judicial review. And if the court finds that the particular statute is ultra vires on grounds of legislative competence or violating constitutional limitations, what does it do? You can't have a certiorari to quash a statute. You can't have a mandamus to quash a statute. The only remedy is a writ of declaration. And that writ of declaration has been a remedy right from the beginning. What does the court do? It declares a particular statute as ultra vires for a particular reason. So it will be wrong to say that there is no sanction of the Constitution to issue such a writ. And if you see the words which are used for a moment in 32 and 226, for a moment, it says, including writs in the nature of. It does not say writs of this kind. It says including in the nature of. And in fact, when I was reading Basu's book, there are different kinds of writs he has referred to, which are not even mentioned here. So this is a writs in the nature of. So they have kept the power very right. It says Supreme Court shall have the power to issue directions, orders, or writs, including those in the nature of. So I don't know if it's correct to say that since declaration is not there, that power is absent.
Thank you very much, sir, for the answer. I think to take a leaf from Datar sir's advice, there is this very interesting book, History of English Law by Maitland, where he enlists so many other writs, like the famous writ of subpoena, right, and so many others. I think this is a time to transform Articles 32 and 226 by really crystallizing the words of these articles, right, in the nature of or writs, directions, orders, etc. I mean, although we see some kind of activism like continuous mandamus, etc. Now time is running out, but I would just quickly say that I think by commencing this series, we have been able to create a kind of a constitutional nostalgia, kind of taking people to the 50s and kind of asking people to remember the legends of 50s whose great work you have perhaps forgotten. So I thank the college for giving me this wonderful opportunity to commence this series. Particularly, my heartfelt thanks goes to our Honorary Secretary and Director Joshi Madam, our President Bhatkar Madam, all the Management Council management members, and Joshi Madam, and dear students. Now, without because time is late.
Just make one point, Jain sir, with your permission.
Yes, please. And then I will ask
at this point.
Sharath, please make your point.
In fact, Chief Justice Sahi had raised this point when he mentioned Radhesham's case. Sir, if you recall, sir, Justice Ganguly, while making the reference, had said that there is no judgment of any court of instance of certiorari having been issued to quash the decree of a court of plenary jurisdiction. And that is the basis on which the reference was made. That's the basis on which Radhesham was decided in 2015. But I found, sir, that this judgment of the Supreme Court in 1977 2 SCC, page 435, was a three-judge bench of the Supreme Court issued a writ of certiorari to quash the decree of a civil court for it being contrary to the Madhya Pradesh Land Revenue Code. And the judgment was not brought to the notice of the three-judge bench in Radhesham versus Chandran.
No, can you repeat the page number?
Sir, 1977 2 SCC, page 435.
435.
So I think the underlying basis of Radhesham is questionable because, in fact, Chief Justice Ray in this case specifically says that one of the principles on which certiorari is issued is where a court acts illegally and there is an error in the face of the record. If the court usurps jurisdiction, the record is corrected by certiorari. In this case, a glaring instance of such violation of law, the High Court was in error in not issuing a writ of certiorari. The decree is quashed.
Justice Shai, you want to say anything? You want to respond? Otherwise, yeah. Sir, please unmute yourself, sir.
Yes, please. Can you hear us? Can you hear me?
Yes.
Yes. This washing of proceeding before a court, if I'm not wrong, the principles of Order 7, Rule 11, Civil Procedure Code, I'm talking of the principles therein, but a writ can always be exercised to quash a plaint if the entire proceedings are without jurisdiction. So, with all due respect, Radheshyam is somehow the other not digestible to me also, but we can't help it. It is law of the land.
No, and I may add here, we are traditionally told a certiorari lies of a superior court to set aside orders of an inferior court, subordinate court. So once the subordinate court, and I basically don't like the words inferior court, all are courts, but anyway, the court of a court below the higher court to set it aside. Yes.
Exactly.
No, the other question which has always occurred to me, that in 32, Supreme Court has power of certiorari. Can it use the power of certiorari to quash a High Court order? No, technically speaking, because the High Court is not the Supreme Court. But I would say that it cannot do that. It can set aside the High Court judgment. So there's no need to use certiorari in that sense.
Exactly.
No, and the only answer to that, my own answer is, there is no writ against the High Court's judgment. It's not a High Court judgment under 226. You can only go under 136. You can't file a 32 against a 226 order. That's now settled by Naresh Biraskar and Basheshwar Nath and so on and so on. All over.
And other judgments also, we say that one writ cannot be used to quash another writ.
Yes. Yes.
But
True, very true.
Would it be problematic? No, that is considering the fact that this 1977 judgment is also a 3-judge bench, and Radheshyam is also a 3-judge bench.
Wait for another judgment.
wait for 5 judges now. No, but actually, the Sharath, you can write an article and perhaps request an appropriate time to refer it to 5 judges. Yeah.
Okay. I mean, this is the benefit of having Datar sir and Justice Sahi. Always keep on learning new points.
Dr. Jain, I want to make one request. You had 8 webinars on important judgments. You can just capitalize in 2-3 pages what are the summary of what to discuss and all these things. It will be useful.
In fact, we are going to have a summary of each seminar followed by a link on our blog as well as on the blog of Law and Other Things. And that also will do our promise. Now, may I ask Kendri, my colleague Kendri, to just propose vote of thanks and conclude this series.
Yes. Thank you, Jain sir. Good evening. It's my privilege to propose a vote of thanks for today's session. I am on the behalf of Center for Public Law, ILS Law College. I would like to thank today's Honorable Speaker, Chief Justice A.P. Sahi, Madras High Court, Chennai, for enlightening us with their presence and took out valuable time for their busy schedule. I also would like to thank Mr. Arvind Datar, Senior Advocate, Supreme Court. I also would like to thank Professor Arun K. Thiruvengadam, Professor Azim Premji, University. I also would like to thank to Mr. Sharath Chandran, Advocate of Madras High Court. I also would like to thank to Dr. Sanjay Jain sir, Principal, ILS Law College, Pune, for moderating today's session. I also would like to thank Ms. Vaijayanti Joshi Madam, Honorary Secretary, Indian Law Society, for her constant support. Thank you all once again.
Our audience also has to be thanked. Thank you very much.
Yeah. Thank you.
Thank you, sir.
Thank you, Dr. Jain. Thank you so much.
Thank you, sir.
Thank you.